Welcome to today's work session. Today, everybody's here except for Commissioner Hadcock. So we'll have a roll call and determine this quorum when everybody's here. A moment of silence. Jerry, if you could lead us in a moment of silence and pledge allegiance, we appreciate that.
Yeah, our moment of silence again, just remember everybody that's in the Middle East and our soldiers and warriors that are over there, fighting, and remember the fallen. Pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, so we just need a motion to approve the agenda as presented.
Mr. Chair, I'll make the motion to approve the agenda as presented.
I have a motion from Ross Connect, second by Drews. All in favor say aye.
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 Motion carries.
Mr. Chair,
Yes.
Commissioner Roskinek did a very good job in your absence.
I heard that. I was like, I didn't know if I should come back or not. I mean, that was like the second
Thank you,
or third.
Jerry.
That was the second or
Appreciate
third commissioner that told me that, so I'm like, heck, maybe I could learn something. But I came back
Okay,
anyway.
let's get going here.
All right. But I know he was out fishing too, so I seen the fish. So speaker request forms are at the back of the audience, but really nobody understands what we're going to talk about today, so we'll just get underway here. So commission work session items from planning department, drainage commission update. No, thank you. Tyler's giving us that, huh?
Yeah, the speaker request form.
No, I can fill one out.
He's going to be the referee for the boxing match we got coming up. So
Yeah.
we'll tell you about it later, guys.
Tyler Sobczak, State's Attorney's Office. So we figured while we're here discussing a litany of other topics that it may as well be a good time to update you on the dissolution of the Drainage Commission. This has been something in the works for a year or two now, but recently I made contact with counsel for the city, Carla Cushman, and counsel for Box Elder, Matt Nas, hashing out how this dissolution would work, just so for the commission's benefit. This is a drainage basin commission under 46A 10B. Therefore, dissolution must be done via joint powers agreement. We had toyed around what that JPA may look like, and we've recently come to the agreement that this could be done via passage of resolution by each governing body that would be passed in their own regularly scheduled meetings and then tacked on to the end of the JPA. We discussed last week that fact, and I also looked into whether there were any lands remaining in the name of the Drainage Commission. It seems like they've all been disposed of, but for now, since we've got a path moving forward, we've circled an initial draft of a JPA, and once we tinker with it a little bit, we'll get a resolution and any feedback from you guys on that JPA. So any questions about, well, and after that's executed, of course, I think it's the intention of this commission to create their own drainage commission that would probably be funded with the 5 commissioner positions, but of course that's early, and we can tinker with that however you see fit. But any questions on the drainage commission?
The only question I would have would be is, do you have a time frame so we can get this done, closed? Because Brittany's been on my case about this.
Yeah, sooner rather than later. Now that we've got an initial draft, we just got to tinker with the fine language and get a draft in probably in front of Jordan for his blessing as well. But I think sooner rather than later would be your answer, Commissioner.
Thank you, perfect. Any other questions from the commission? Seeing none. Thank you, Tyler. We'll move on to the next item. Brittany? Jason? Both of you guys, I guess, or whatever. We're here to listen.
Morning, Commissioners. Jason Thennison, Assistant Planning Director. See if we can get this up on the screen for you. So we're talking about the 40-unit rule. I drafted up a memo for you. The subdivisions that we have going on in the county tend to involve 40-unit rules. It's been a constant struggle to figure out the best way ahead with that. More or less, it puts the board in a difficult position as de facto planners for these 40-unit rules, and that's kind of what we want to avoid moving forward. So what we're asking today, I guess, is, we've done a lot of research on how best to manage these dead-end road systems and what to do in our department, but we would like to involve some other departments in the county, emergency services, Jerome from fire, maybe Chip from the city fire as well, to see what the city's doing, the state's attorney's office and the highway department, to kind of form a working group to figure out what the best way ahead is on this, because I don't think us making a decision in the planning office kind of in a vacuum is the best way ahead. So if you agree with that, we'd like to move forward with a working group. If not, we're definitely open to some suggestions and guidance.
Yes, Commissioner Drews.
I don't have any objection to the working group, but I think there should be a commissioner
Yep.
on that working group.
Yep, I agree with you. And do we got a volunteer to be on that group, or one of us want to volunteer, or?
Well, Mr. Chair, I guess it would be the two larger districts that are
I
facing.
think it would be nice to have you there, because a lot of this affects what's happening in your territory. So, I mean, that's up to you, Ron. I don't want
Well,
to.
it only makes sense. It's going to be the commissioner that gets the phone calls.
Yep, okay.
and-
So we will do that. So I guess, Jason, we will have Ron involved in that conversation.
Or the commissioner for District 1
Yeah.
going forward.
Okay, so we'll just designate it as District 1 Commissioner in case, I guess might not be coming back but
Right.
you still have a whole year, so we should get.
Right, but I just-
Probably, it'd be nice to get this done before you left, so you had a signature piece of
Absolutely,
legislation.
but I just,
We're gonna call it the
okay,
Ross Connect
I like that.
resolution.
Yeah, I like it.
All right, so then, I think, Jason, if you want to get all those other people involved, you're gonna need someone to help coordinate that, so I guess we could volunteer Jordan or his office to do that, not him particularly, but your office, Jordan, does that make sense? To help.
Absolutely.
Help, herd the cats for Jason to be able to move that forward is something we want to get moved forward sooner than later, so, but.
Mr.
okay.
Chair, we're looking at various stakeholders. Would we want to get somebody that does subdivisions, just somebody from that group?
So, Mr. Chair,
Yep, Commissioner Durr.
yeah, my comment on bringing in citizens at this point in time or someone on the outside, I would like to keep it internal county working group, and primarily because we're currently tied up in legal on some of these issues.
Okay, that's fair enough.
Perfect.
Yeah,
Good question, though, that.
just like the idea that we're going to address this because.
No, I think we're going to address
it.
it, and I think having conversations with the commissioners up here, we're all probably in the same arena that it's long overdue, that it needs to be addressed, and so I think they'll come back and make sure we address all the fire hazard or any other mitigations that may have to happen, so.
I'll go ahead and make the motion to move the direct staff to proceed evaluating options and proposed changes to the 40-unit rule ordinance.
So,
Second.
a motion and a second. All in favor, say aye.
Aye.
Opposed, same sign. So, Jason, we gave you some marching orders, so we hope that you can get with Jordan and get back to us as soon as you possible. We're not going to put a specific timeline, but we'd like to get that ironed out
I
real
wouldn't
quick.
think this is going to take very long.
Yeah, I didn't think so. I mean, if the less people you have involved, but have the key people, I think that's the way to get it done. So maybe have 2 meetings, maybe you should be able to get it done. So, all right.
All right, thank you.
Yep. Bubba Brittany, you're up to bat here, girl.
Let's see. All right, so this one is a proposed MOU for the 3-mile plating. So actually today on the Planning Commission agenda, and the board will see this on the April 7th, there was a property that was bisected by the plating jurisdictions. So in these cases, the applicants are required to navigate 2 separate plating jurisdictions and processes. So they'll have to plat through the city and they have to plat through the county. So we're proposing that we enter into an MOU working with the city's planning department to designate one jurisdiction. So these property owners aren't having to go through 2 different plating processes and then file one plat that has all of our signatures on it. So it's like duplicating, so they have to go through both processes. Staff have to work together. Like today, they have to file 2 separate resolutions. So they had to hire an engineer to do a resolution for the north property and hire a resolution, or the engineer to do a resolution for the south. And they have to filed 2 separate resolutions with the Register of Deeds, one that's in the counties and one that's in the cities. So it's a very cumbersome process, and it's been going on for some time. So we would like to work with the city to try to get some kind of memorandum of understanding or an intergovernmental agreement together with them, so that one jurisdiction actually takes over the process. So it's not both. Right now, the way that the city's 3-mile plating jurisdiction works is it's almost like a bubble. It does not follow the property lines. So either we change the way that they look at their 3-mile plating jurisdiction, or when it is bisected, that if it's the majority of the property is in one jurisdiction or another, that jurisdiction takes precedence. So right now in the statute, it does require both of them unless there's some other agreement in place. So we're recommending that we work with the city of Rapid City and legal to try to get something in place. So this is an easier process for the citizens.
Perfect.
So.
Yeah, I know we've tried this in the past. I think we can make it more earnest this time to make it happen. Do you need us to give you some direction on that, just to say approve something to go forward with this? And do you need who do you think you need? Do you need like a commissioner to help you get this resolved?
I think that would be pertinent to have a commissioner.
And
that
I'll
works
volunteer.
with
I'll
the
volunteer Brittany for
process.
that one. Vince.
And then working
Connections.
with Vicki Fisher with the
Yep.
city, so, and then a council member probably to get this moving forward. So it's easier on both the citizens, in the process. I know some of the engineers have
Right.
expressed their concern about the process as well.
And it's a
So-
level of frustration for everybody involved. I mean, so I think it's a great opportunity. We've been really working on getting the city-county relationships like this, and I hope that helps. Also, what we talked about earlier about what was really most important to me is drainage. So when we get that resolved too, that's gonna help a ton, because then we'll still have control over that drainage issue without having all this other discombobulation. So do you need a
Mr.
motion from us?
Yeah, Mr. Chair.
Yes.
She has a recommended motion. I'm going to move to direct staff to proceed with the proposed and a draft formal MOU regarding the 3-mile jurisdiction.
Second.
We have a motion and a second. All in favor, say aye.
Aye.
Motion carries. Great idea, Brittany. Move on to the next one.
Okay, so this one is our proposed ordinance amendments. We are looking at changing our ordinance amendment schedule so they're just not coming at random times anymore. We're going to work on them so they're twice a year, because every time we do an ordinance amendment, our whole zoning ordinance has to update. So we have so many different iterations of the zoning ordinance based on one section being updated. So we would like to work on them, get proposals in front of the board and direction from the board, work on those during that time, and then bring them forward twice a year in June or July of the year. And I mean, I know that in some instances there'll be some timing issues where we can't do that, but to save, so we don't have tons of iterations of our zoning ordinance, we'd like to establish it in just 2 amendment cycles a year. So some of the ones that we're looking at are home occupations, is to add criteria and establish a dedicated section, and it provides clear standards and improves consistency in administration for home occupations. There's a lot of different home occupations.
Oh, okay.
Yeah,
Gotcha.
and it still would be a conditional use permit, but we don't have like set criteria. What does that mean? Does it have to be in an enclosed structure? Can they have items outside of their property? We have one right now that we're working with, I believe Commissioner Weifenbach, you're aware of it, in the Valley. So just, providing what are they, a contractor storage? Are they a home occupation? So it provides clear criteria for those. Utility lots, examples are like well lots. This would be creating a new section that would allow it as an exception, because right now if you do a subdivision and it's in a zoning district, you have to get a lot size variance in order to have a utility lot. And if you have a subdivision right now, I think the last one that we did was along Sudbury Ranch. There was a well lot variance, and it created a lot of somewhat controversy and confusion for the property owners up there, because they thought that these lots were going to be 1-acre lots in this Sudbury Ranch. So this would allow the utility lots to be done as an exception. It would still be part of the plating process, but it would eliminate the need
I'm
for
going to
a
stop you there,
variance.
Brittany, just to get my arms around that. So the utility lot would be something that basically would not be calculated in the size of the lot. Is that what you're thinking?
Correct. So
Okay.
it would be an exception to the zoning requirements. So if it is, but it would have to be a utility lot that serves the subdivision that's being
Right,
zoned.
okay, that makes complete sense, okay.
And then section 506, this did come up in one of our variants, some pre-permit activities to clarify the allowable activities prior to a building permit issuance, like the dirt work, the one that came up before. So we're very clear, and it reduces ambiguity to the applicants and
And these all
enforcement.
will be thought about as ordinance changes.
Correct.
Is there a way that maybe we could change the ordinance, but they go into effect at one period of time? Would that make more sense, so we don't get flooded with a bunch of them at one time?
Right, so that's what we're working on.
Okay.
Is
So we'd
we'll
have like 2 times a year where these ordinances would happen? Is that what you're
Right,
thinking?
unless there's
Okay.
something that comes up, like we have our solar and wind, that we do have a deadline for that, so that one will be a little different. It
Right,
wouldn't be
okay.
held out for that.
Yep,
And then the impervious surface standards, that's in section 507 right now. Right now, they're different. The commercial is at 15%. Typically, commercial has more impervious area, and they're typically the ones that actually put in infrastructure for retention and mitigation. So it's just making those the same at 30%. It corrects the current inconsistency and and aligns with the typical land use practices. And then section 511, section line regulations right now, we just have a section in our ordinance that relates to a fee. There's no like requirements under our zoning ordinance right now. There's just in our subdivision regulations. So that is something that I think Joe and I and Commissioner Weifenbach are going to work through to make sure that it aligns with the statutes and our
this is
zoning
where the
ordinance.
boxing match comes into play, guys. So Brittany and Joe are gonna, and Tyler's gonna be the referee, so.
Mr. Chair, Brittany, can you expand on how that's going to work the way it currently is now? And then if you propose this, how that's going to work? Somebody applying, I've gone through this with the section line relocation, vacation of section line.
Right, so currently, right now, the section lines, the only thing that in our zoning ordinance that references section lines is a setback of 58 feet and a fee. But there's no criteria or anything because it defers to the statutory requirements, which are under 31. Planning items are under 11.2. Right now, if it has to do with a subdivision, then it would fall under our subdivision regulation variances. But if it's outside of that, it's kind of in a, when people ask us, where does it say that, we have to defer to statute. There isn't anything in our zoning ordinance. So it's just kind of cleaning up that process so people actually know what that process is, whether it be through our office or the highway department. I think it needs to be clarified for the applicants, because there's instances where they will go to the highway department and they'll have them come to us, or they come to us and we have, so they're kind of bounced around. It would be nice to have a clear process written in ordinances on where that process is housed, essentially,
Okay.
and what that process
Make sense,
is.
Ron?
Yeah.
Okay, perfect, okay.
And then the other one is a conditional use permit review fee. Right now, we have a conditional use permit review fee for vacation home rentals only, but no other ones. And some of these older conditional use permits are taking up a significant amount of staff time. Even though they're on a consent agenda for the Planning Commission, they are still taking a lot of time for staff just to establish, compliance.
What is our fee for a vacation home?
It's $100.
Okay, so you're looking at something similar to that? or-
Correct.
Okay.
Because we do site visits,
Right,
we do
yeah.
meet with the applicants, we
It
call
should-
the
It
applicants.
should, at a minimum, it should cover the cost that it takes, but Commissioner Durr has a question.
Yeah, I'm just saying, when you take staff out and do site visits, and a lot of the work that I've seen on these conditional use permits to go out and do the site survey and do all this other stuff, $100, depending on what it is, but, some of these other conditional use permits, if we're gonna implement a fee, getting back to the point, it should cover our time.
Correct, and I think ones that do deal with mobile home parks, those take a significant amount of time, because you're looking at every site. RV parks, things that are a little more contentious do take a considerable amount of time, and I think we could make those different based upon the types of CUPs
Right.
that they are.
And while we're talking about this,
You get the floor.
Tyler,
Oh, it's the consent agenda.
Oh, yeah.
conditional use permit, are you tracking the case at the Supreme Court right now?
The Lawrence County one?
Yes.
Yeah. So I believe that they've just finished briefing that, but that it was an administrative, right, that was the administrative decision, one that was subject to appeal.
Correct.
I haven't been tracking the briefing, but I know the circuit court sided with the county and that's on appeal with the Supreme Court, and we'll wait for the guidance from the Supreme Court then.
I'm sure that we wouldn't mind just giving a little brief summary, because I don't know what you're talking about.
Yeah, how about I'm not prepared to do that in
Oh.
full transparency today, but let me read their briefing about what's on appeal, and I'll get back to you. And
Yeah, I don't even
can
know
brief
why it
and
went
maybe
to
send
what
it
the
to board.
problem is, but that's fine. Yeah, we don't want to waste everybody's time, but if you could.
No, it's just a conditional use permit that was, you have 20 days to appeal, but it's a question as to whether it was judicial basically or administrative, and whether you can appeal that. And then it got into the whole discussion about us going into the Board of Adjustments and offering those conditional use permits under, the Board of Adjustments. And so it's an interesting case.
Okay.
Yeah, the way state statute is laid out right now is, well, and our zoning ordinance is conditional uses are granted and reviewed by our planning commission. However, 11253 does also allow the Board of Adjustments to hear conditional uses. The precedent that will be laid down from the Lawrence County case essentially will, deliberate the best course of action for what governing body should hear those appeals essentially.
Okay, I know when I was with the city would hear every kind of an appeal. Mm-hmm. And when I came to the county, they're like, we don't hear those. I'm like, well, why wouldn't you? Because we're the elected officials, the ones that the people put in charge.
Yeah, right now I believe the Board of Adjustment hears revocations, but not reviews or the actual grant of the conditional use permit. So
I mean, if I get, just not that I get the Supreme Court will decide, but if I was a citizen, I'd be pretty upset if I couldn't have my elected official give me, some other, you've probably seen this commission's not real thrilled about committees and stuff like that. So, but anyway, thank you. If you could just give us a little summary when you get time. Brittany, you have the floor.
All right, so the conditional use permit review fee, and then moving on to ordinance 735 building codes, there's some things in here that will need to change based on some legislative updates, and Tyler will go into those later in the meeting. But we do want to update some contractor licensing requirements and provide some additional clarification for administration and compliance. Now that we've had this ordinance in place for a while, we have a building inspector. We've learned quite a few things, so there's some things that potential changes that need to be made.
Now, I'm not sure if there was somebody on the commission here or if it was the home builders on behalf of the home builders, but they talked about building inspections in the county, because as these properties are being more and more built in the county, having some proper building inspection just to keep the honest contractors honest. I remember being at the city, and one of the things they never did inspect was the most fundamental piece of a house was the foundation. I mean, they never inspected the ground these foundations were put on. There was never any requirements for the foundation, and because of the ground that we have available here to build on, these people's basements were crumbling and stuff like that. Have you guys heard anything about the contractors wanting an actual larger or a more detailed inspection, or maybe framing, footing, and vinyl or something like that? Yeah, Commissioner Drews.
So at one of the home builders meetings that I went to, that's what they talked about.
So it's probably you that told me that.
That wanted to be more advanced. They compared us, I think, to Meade County at the time. And that was the discussion that morning as I talked to individual home builders after that. I mean, and my comment was if it's going to be additional inspections, et cetera, it's probably going to be more of a cost. Yeah, they weren't interested in more of a cost, but so I mean, I don't think that's a statement that they would want to stand by at this point in time. Okay. We could certainly ask them for
something we may need to look at, though, just to protect the people building the house.
Right.
Because if you got a house that's built on a foundation that's going to crumble, and the next guy that comes along to buy it is unaware that there was never any process to, I mean, in that basement crumbles, I mean, it's sad for the people, 3 or 4 years down the road, so.
Well, I think when you start looking at the comparison of how many home starts that we have in Pennington County compared to those others, I mean, that makes a huge difference, so.
Yep.
Mr.
Agreed.
Chair.
Yep, Commissioner.
Jared, did you want to speak?
Commissioner Roskinek?
My concern is if you go too deep, my understanding that the building inspection, they'd come out and just make sure that the building met the required setbacks and some fundamental items. In my opinion, if we go too far and say, yeah, that foundation looks good in 10 years, it doesn't, then we're putting all that weight back to the county by that building. I don't know how deep they want to go. I mean, I understand setback requirements and whatnot, make sure that it's complete in their opinion, but sit there and start saying some building characteristic is okay. I think that's going a little too deep. I don't want to put that much weight on a county building inspector, or that much legal liability. That's my take.
Brittany, did you want to respond?
Commissioner Durr.
Durr, go ahead.
Could you explain what the current process is?
Sure. As part of the current process, our building inspector goes out and verifies the initial setbacks. So it's staked out, he verifies that. And then he doesn't go back out again until the structure is complete. He verifies that they built what they say they were going to build, that they have their final inspections from the state for their plumbing and electrical. And then their septic was put in and approved. Right now, just with those items, our building inspector we would have to hire additional staff in order to do any more inspections than what we have. Going to this process was a huge step in comparison to what we did before. It was absolutely nothing. And it does help equalization, because David does provide information for equalization when they go out and verify and they know what was there. The reason that we started that process is because equalization would go out 2 or 3 years later and there would be a single family residence and things like that, and they have a building permit for a garage. So it kind of has helped mitigate some of those types of issues as well, but we would have to hire additional personnel and training. We do have 2 individuals in our office that are ICC certified, so they do have knowledge of the codes and things like that. So it's not like they're completely untrained to look at some of these things. It's just that we don't specifically inspect. And we have talked about with staff, with the state's attorney, and I believe Commissioner Drews, you did come into the office and talk to David. There's some concern about the liability of the county if we start doing more intense inspections. So that was
Again, and going back to what Commissioner Roskinek said about, and Commissioner Drews about, I don't see a real need to act unless we get a lot of complaints. What happened at the city was they were getting a lot of complaints about the foundations crumbling, getting water in them, and there was never, I mean, when you build a house, the biggest part of the house is the foundation. If the foundation's shot, your house is shot. I mean, it's completely ruined. And then that's when we enacted the whole thing of having to have an engineer. So it shifted the responsibility to the engineer that was, saying this is how the foundation needs to be built. I know they do it in Wyoming, whatever. But if we don't have a lot of complaints about it, I don't see any sense of trying to reinvent the wheel. But if it's something that we're getting complaints about from homeowners that are buying homes and unexpectedly, because now, like Gary said, we're getting a lot more houses built in the county than we probably ever had in a long time. And at some point, these houses are going to recycle through new people, and if issues come up, then I'd like to be ahead of the game versus behind the game going, sorry, your house foundation crumbled or your whatever happened to it, so.
Mr. Chair.
Yes, Commissioner Durr.
So Brady and I had this conversation, about this time last year, because there was a subdivision where a developer and a builder did the subdivision, and there were problems in that subdivision and complaints coming in, and the gentleman came forward and listed his complaints and spoke at a public meeting. That was kind of his issue, is that he thought that there was a permitting process where they went through and that we were signing off on some of these things. And obviously what happens when you buy a home that is substandard, unfortunately, and the developer says one thing and does something else. There are counties that do go out, and Meade County is one that, let's say you build a pole barn or you're doing anything, they go out and there's a process where they go through the checklist and you look, okay, are the footers in correctly, based on with the requirements in the ordinance and, kind of those different phases going out, signing off on the plumbing, electrical, even though the state comes out and does some of that. So I do know that there are some counties that have that in there. And I did hear something last year. I did step in for a meeting that you couldn't go to, and I had a meeting with the kind of Builders Association, and kind of echoing what Commissioner Drew said, some of this stuff bubbled up. So as we're talking about this, and I know you guys talk to them all the time, but could we have that communication with that group again and kind of see where they're at with some of the things we're looking at doing and what their thoughts might be on this?
Okay, definitely.
Chair.
Yep, Commissioner Roskinek, sir.
An example, a couple of years ago, I was sitting on a friend's deck. He just built the deck, and I didn't know Dave. Dave come out there and had the county license plates on, and so he was inspecting the deck. So what Dave did is he measured the deck to make sure the deck was the right size, looked at the setbacks, and just that generally it was built as described in the building permit. What he didn't do is get a tape measure out and measure 24 inches on center, or didn't go into that much detail. But I think what Dave did is exactly like Brittany said, just verified that the general concept was there, it was built, it was complete, and it goes on to the county assessor who will put it on the tax rolls. So I like the way it is now, and if we need to look at it deeper, we can certainly do that in the future. But I thought that's to me an inspection. So
Yep, I think that's how they handle them right now. But
No, in essence, I mean, yeah, we're looking to make sure if you say you're going to build, 600 square foot structure or shed or whatever the case may be, the county always wants to make sure we're taxing appropriately.
correct. All right, I think you answered all our questions. So
So if anyone has any questions, with the exception of the section line, we'll get together.
yeah,
but
we'll get
move
together on
forward.
that one. So we don't want to make any action on that right now.
Right, so these are just kind
I'll
of
tell you, give Joe a right hook.
so these are what you guys can anticipate to see coming forward. And then the last one is our vacation home rental. So we changed our ordinance, the vacation home rental, and went to a licensing, which was in essence supposed to make it a simpler process. I mean, it's a checklist, it's administrative.
From the
and-
government, and I'm here to help you.
So basically, we're on a complaint basis, and we haven't really had a whole lot of compliance, to be honest. And there is concern from the people that do comply with the people that don't comply, because there's a lot more that don't than do. So staff is kind of looking for some direction as far as either we have a more active enforcement approach, or maybe we just don't have the licensing and it's just allowed. I know the state does do their lodging license requirements. Some of them, they don't. I mean, there's a lot of them that don't have licenses with us or with the state. The city did recently pass a vacation home rental. They call it a registration. It's very similar to what we do with the licensing. They are actively enforcing it. They did acquire some software that goes out and data mines all of these different ones and provides them quite a bit of information. They can tell them how many nights they're rented, what types of year they're rented, what the cost is per night, what the revenue that they're bringing in, different things like that. We have looked at similar software. They are using Granicus, which is not something that we would want to use. There's another one that we looked at is Rentalscape. I think it was $13,000 and some change a year. With our current every 3 years, $150 for every 3 years, it would pay for itself if we were to go to the active enforcement. But right now, it's just it's on a complaint basis only, and we get a few complaints here and there on them. But there's far more that are operating that aren't licensed or have a conditional use permit.
Brittany, I think this goes back to kind of what Ron was talking about, trying to reinvent the wheel here, or we're making a solution for a perceived, or making a problem for having a solution that creates a problem. And it also kind of goes back into why we changed all the nuisance laws. We already have laws that cover all this, so we're gonna lay on another layer of laws. So if your neighbor, for whatever reason, doesn't like what you're doing, they turn you in, and then all of a sudden that neighbor turns in another neighbor, and then all of a sudden we've got chaos. But I'll leave it to the commission here
Sure.
to, Commissioner
A few
Roskinek.
years ago, this was just a constant problem in my district. I mean, I got the emails, it's just, and it came in front of the commission quite a few times. Last year or two, it just seems like it hasn't been a problem. And I like the idea, if somebody complains, we go out there and take care of it, but I don't want to really go any deeper than that. I think we got enough things to do as the planning and zoning office to really dig in too deep. Just let it run its course, and we get a complaint, we'll take care of it.
Commissioner Drews?
At what level or what time do they need to register with the state? There's a requirement of registering with the state, but some don't have to, right?
They all should. A
Oh.
lot of them don't. They don't register with us or with the state. So before, we had the conditional use permit process, so we would go and do a deep dive. We would go out and do the inspections and everything. And then we changed it to this licensing process, because if you get the state license, they actually have a health inspector that goes out and does all of the inspections. So there was really no reason for us to go through that. So that's why we did the registration process. The registration process basically checks off all the boxes to make sure that they do have their state lodging license, that they have a Department of Revenue, that they have their sales tax license. And the other biggest one is that their septic is sized appropriately for the number of people that they're renting to. So it's more of a verification. It's $150 every 3 years. We just verify that all of these requirements are being met, that they have gotten all of their things. Instead of going through the whole hearing process like we used to do. We were hoping that going through this licensing process, which it really is administrative, would encourage compliance, which it has not.
So is there a standard fee for the state, for registering with the state?
I believe it's 125 or 150. It's similar to what ours
Okay,
is.
does the state do any kind of enforcement on, if they find out that somebody is not registered?
Not really. We haven't seen that.
Okay,
They don't actively go out either
okay.
and do that.
So, not meaning to interrupt, but I
Just
know where
one
you're.
more question, one
Go
follow-up.
ahead, yep.
Any idea how many are not registered?
So when we went through this rentalscape, they just kind of did like an overview. Obviously, it's a sales, but we probably have, I would say, about 125. I'm guessing we have upwards of 350, I believe is what he's, about 400
Not registered?
total. So we have a little over 100 registered, probably about 125, either that has a CUP or a registration.
Okay, compared to how many are unregistered?
Correct. It's significant. And because we've been going on the complaint basis only, so if we actively enforce through the similar process that Rapid City is, because now you'll have Rapid City that's actively enforcing. So, for instance, you could have a property in Rapid Valley that's on the city side of, like, say, Avenue A, and they're getting, they have to register with, the city and do all of those things. And you have one that's on the other side that if nobody complains about, they're just doing whatever. So that's kind of our concern a little bit, like out there now that the city is actively enforcing. We just wanted to bring it to the board's attention, just to
Mr.
see if
Chair.
it was.
Yes, Commissioner Roskinek.
So if we bought that software, that'd just about be a full-time job, in my opinion, to sit there, if you got that many out there, trying to, I don't know, it just seems like we're just creating another job for ourselves.
No,
I mean,
the software does all the work. They do all the data mining, and you can actually have it so they actually send out the notices and do that.
But I
So-
just see we're bringing on a lot more work.
You're the guy that gets all the phone calls.
I haven't got a phone call. When's the last time we've had a complaint on somebody being non-compliance with a vacation home rental?
In my district.
Yeah.
All in your
We've had a
district?
couple in Commissioner Durs of late. But
I
it's
think it's
usually,
something that
like
we
I said,
gotta-
it's neighbors.
Something that we got to keep on the radar, but I don't know that I'm quite ready to invest in a
get
program
resolved?
that's going to put more work on your department.
Did they get resolved?
It will
Yeah,
be
Mr.
in
Chair.
front of your,
Commissioner Durr?
Yeah.
yeah.
So, yeah. So a few months ago, I mean, it's been, I don't know how many months ago, Brittany and Jason brought attention to an individual in my district that is in non-compliance on multiple levels, and it has taken a lot of staff time. We had a meeting with the individual, and still not compliant, and I believe that one is coming in front of the Board of Commissioners.
Correct. It'll be the second meeting in April, I believe. Yes.
Okay. And then again, what goes with this, when you find somebody that's operating like this, and again, it goes back to, part of the property through the complaint process, we found out, equalization didn't have the property properly assessed. They had this, not just interior finishes, but square footage, all kinds of things. And so, anyway, that one is coming in front of the commission.
Okay.
And I'm just going to ask to Jason if you would step up as well. So this kind of goes back to one of those, kind of goes back to our nuisance things. If you see it, you can't unsee it. You can't go address, one nuisance in Green Valley Estates and then look to the left and the right and see the same situation. And then it goes back to, again, I wasn't on the commission then, but I know that you guys spent a lot of time on this ordinance. It went back and forth. You had many public hearings, in 23, 24, something like that. And then it goes back to if you have something on the books and government's going to regulate, but you say that I'm not going to address it. And what I'm hearing is that we have only about a third or less of compliance.
Correct.
And so, in my mind, at the very least, either you look at the ordinance and say, we're not getting compliance, we're not enforcing, do we need the ordinance? And then secondarily, if you can get the software or something that goes, because my thought was, if you've already kind of done the data mining to find out on whatever site you're using right now that you have, we have 100 plus, but we have 400 vacation home rentals in Pennington County, just to send a courtesy letter to those individuals that says, here's the ordinance on the books, you may not be aware of this, but here's the process, blah, 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 blah. Please get into compliance and see what kind of response you get on that. But if we have something on the books and we don't want to do anything about it, and we're not getting, good compliance with the ordinance, and then it goes back, and I understand what you're saying, Commissioner Roskinek, but then again, it goes back to, you spent so much time in public hearings and public input on this, and I remember some of it not being on the commission at the time. And so what outcome are we trying to get? And so that would be my question to you. What is your preference? What would you like to do?
Well, we would either like to be able to enforce it or not have it, because that's, either one we would be fine with. This kind of in the middle, like I said, we hear a lot of complaints from the people that are compliant because everybody else isn't compliant. Even with the gentleman in your district, there's, he got complaining about from a neighbor, so now he's got to jump through all these hoops, which he needs to. But yet there's other people out there that are doing the exact same thing as him, but they have neighbors that have never turned them in. So it's kind of that fairness thing. So we feel like either we should actively enforce it or just not have it, because it's there's just not enough compliance for it, but there's also not enough complaints. So
Mr. Chair.
I guess that's the question that we're asking the board is, what is their wish? Should we?
Commissioner Roskinek has a
So
comment.
I'm just trying to, look at those scales. So if we decide to go the route that you're talking about and invest in this program, and how many out there non-compliant? 300?
Roughly 400.
Roughly 400. So my concern is that, let's just say 10% of those become issues, and now they're gonna, I just see really getting bogged down with paper, but I just see it really, I don't, the 13,000, I don't have a problem with that. It's just that if we got 400 out there, I just think we're really getting into something that we're gonna probably wish that we hadn't. I'm just looking, if we do that, what's the benefit to the county? I mean, if we just like you said, just get rid of the ordinance, whatever. But if we go ahead and do this, are we looking at the fees that would be involved, that they would pay the county, that's gonna make it worth our time to do this? Is that we're gonna get 400 non-compliance, they're gonna have to pay $150 a piece, but they're in the system, they gotta be monitored. I just see a lot of work. So if we don't do it, and we, dissolve that ordinance that you're talking about, what harm's it gonna do to the county? I'm just trying to look at both sides and see which one makes the most sense to the county and the workload of the planning and zoning department.
Mr. Chair.
Yep, Commissioner Drews.
So, question. So Rapid City and Hill City both have their own individual ordinances, do they not?
Correct.
None of the other communities have an ordinance on it. And so like, if there's a VRBO in New Underwood, is that our responsibility then?
That
If
would
it's
be the
within city limits, it's not.
Correct.
Okay, so it's got to strictly be outside of municipalities in order to be our issue.
Correct.
Okay.
I think there is, if I could, Commissioner.
Yeah, go ahead,
So,
and you can chime in.
I do believe that our offices, we exist for health, safety, and general welfare, and I do believe that if we scrap the ordinance, it would be kind of a disservice to the rest of the county, because that's what we're doing. We're ensuring the bare minimums with the ordinance that we have on the books. It's a checklist just to make sure they
I
have the
get
state
that checklist thing, and I get all that, but
and all of that.
what is the, if I have a VRBO in Pennington County and I don't get a license, what are you gonna do to me?
Well, at this point, it'd be an ordinance violation, and we'd follow it to make sure you get the license.
What if I don't get the license again? I mean, what is the end result? I'm saying, what is your enforcement capability? What are you gonna do to me? That's what the key factor is here, because like the fellow that's coming forward, he's violated the rules, and now we're going to do what?
There's a hearing in front of the board, so the board would either
Isn't
abate
there,
it or.
is this fine spelled out somewhere, or is there a fine?
Yeah,
Is there a?
the fine's in the ordinance. So all of our ordinances, it talks about what the penalty is in every ordinance. So in this case, I mean, it's going to be a civil penalty, I'm assuming.
I think it's $250 a day that they're
Right.
operating without a license.
Yeah,
Okay.
so there is a penalty requirement. We haven't imposed
So
significant.
so $250 a day from what day?
The day that they receive notice.
Okay.
So we either email them or send them a certified
So what-
letter, so we have like a
The monkey really
date.
lies on the back of the commission to do what they said they were gonna do when they made this
Right.
regulation.
Yeah, Mr. Chair, this is why you asked the staff. The commission put an ordinance in place that says you have to do A, B, and C.
Right.
And if you don't, here's a process, and if you don't, here's the consequence. And then, on the other hand, then we're asking the staff to go ahead and enforce that, getting back to what Jason just said, which is spot on. And then you go back and say, well, I don't really want to, we don't really want to enforce, we don't want to do that.
Right.
Then this goes back to government really 101, my philosophy anyway. If you can regulate, you can overregulate, but if you decide that for health, safety, and welfare, that you need to do something and then you regulate, then you need to follow through. And when you talk about complaint-based, so it doesn't, in my mind, you don't have to have, somebody, I'm just going to take my district, somebody, east of me down by Scenic complaining about somebody else down the road that's operating a venue and they have a, tourism venue and they're checking all the boxes. Somebody else is in non-compliance. We already know based on, they've already shown me some of this stuff just in my own district with this one individual, but, when your staff is telling you that we have nearly 400 in non-compliance, they're already aware of that. It's not like somebody's got to complain. The staff is saying, we're in
We're
charge of
aware of that.
operating something. We already know we have 400 in non-compliance. We're telling these people, follow this process. And so 25% of the people are following a process and 75% are not. And that's the question to us. Enforce, and there's a way to do that, using the software, but basically, it was adopted, and I know that you guys spent a lot of time on this, and I only know, I wasn't here, I just saw it in the news. And so you had a lot of public input on this, a lot of back and forth, and with all the public input and all the stuff that came with it, you adopted an ordinance. That is their job in their office to follow through on this. And if we are saying, you know, it's not worth it or turn a blind eye, then you got to give the staff some directions, either get the damn thing off the books or give them the tools to do the job.
Right, and I agree with that too, and but I don't know that we have to police it. I mean, like, spend extra dollars to go out and find and have a full-time person doing it. I mean, but if we run across it, we should send them a letter and say, you want to comply, then we're gonna go after you. So if we come to the knowledge that, say if I know the speed limit is 35 miles an hour, I don't get a ticket every time I go 45 until I get caught. I mean, I don't see any reason other than that. I mean, unless the commission decides they want to invest all this money into chasing all these people down. But if you get a complaint or you're out there and you see another operation and you check the website and that operation's not in compliance, then they'd get a letter from us, and then they pay $250 a day for operations from that point forward. And then it comes to the commission, and the commission can't sit up here and say, oh, we're not gonna do that. I mean, that's
Mr. Chair,
Commissioner Ruskin.
I'm just thinking if we have 400 violations, we send out 400 letters. So that's the start of the process. And then we're going to want a response from 400 people. I mean, if I'm looking at it right. So who's going to send out those 400 letters? How are they going to send the letters out? When are they going to send the letters out? And where are those letters going to come back to? Who in your department is going to have to look at 400 letters to see if they want to comply? It just seems like that's just the start. And then let's just say 10% don't want to comply. Well, now they're in the system and they're going to be going through your department. They're going to be coming to the commission. I see this being another full-time person somewhere, at least for the beginning, until we get it all rectified. Okay. I don't think we have the personnel in your office to send out 400 letters, look at 400 responses, and the ones that don't respond, start legal action. I just see that really something that we need to I totally agree with Jerry. If we're going to have it, we got to enforce it for public safety. But I guess to me, you're going to be looking for another full-time employee.
I guess going down to what are the complaints? Go ahead, Commissioner.
No, I'm just going to say, so I'm going to, put my hat on, going back to my law enforcement days. Got a speed limit. You're correct. How many times does somebody drive and speed before they ever get caught? I don't know what the status is now. I just know that years ago, somebody's going to drive, up to 80 times drunk before they ever get pulled over and get a DUI. But when you put enforcement into that and you set up checkpoints or you do speed enforcement, you say, I'm going to buy, and I don't know if the highway department has any of those, and I know they're out and about, but anyway, you can put up signage, check your speed, here you go, slow down. That's an investment because you're saying, I put something in place, I'm going to invest dollars in that because I'm going to enforce it. And we'll have this conversation during budget time, but not unlike our state's attorney's office and our state's attorney, Laura Retzel, who said, I'm going to do retail theft. I'm going to do petty theft. And what has that done to our court system and the jail and all of that? And that's a conversation about, is it worth it? And so going back to this, Brittany, what I'm hearing is you could do the investment of the software of $13,000, getting back to, Ron, question about who's going to do this, and you're saying the software would, send this stuff out, et cetera. So I think, that's an investment that you could put in, knowing that is out there, and say for $13,000, whatever, we can do the software. But the point being is, you can do all the enforcement you want, but if you don't have follow through, then you have to have a discussion as to why am I doing this in the first place. And so it's either we could talk about how much staff and how much time's involved in all this stuff. The commission adopted the ordinance. This is one example of many things that we have in place for health, safety, and welfare, et cetera. So you took public comment, you took staff comment, you adopted an ordinance. Now it comes time to enforce the ordinance. And if we're saying to the staff, then I think it's too much time and effort to go ahead and do this. The health and safety welfare that Jason brought up is irrelevant. I don't believe it is. then we need to have a conversation. And this is just one example of many, because getting back to your point, Commissioner Roskinek, all of this does cost money. And is this something that we want to do? But I do want some, because this is just one example of many as we go through, talk about what the county is paying for. Are the taxpayers the one that are paying for this, in many cases, getting the bang for the buck? So we either, in my opinion, we either say that we're going to invest in the enforcement aspect of it, or instead of having a 35-mile-an-hour speed limit because I don't want to deal with it, I'm going to make it 75, and therefore I have less to worry about.
Yeah, I'm not real familiar with the legislation. I can tell you if I was sitting here, I never would have passed it, but that's irrelevant. Like Jerry said, it's done, it's passed. Either we're going to enforce it or not enforce it. It's still illegal to feed the ducks in Canyon Lake Park, by the way. That's one I fought. I mean, it's ridiculous under the same circumstance that Jerry's saying. I mean, if some old lady's out there feeding a duck, you going to arrest her? Come on.
And
So-
my mother took my kids out there all the time to feed the ducks. That would have been interesting.
Well, I'm going to go get her.
So, Mr. Chair,
Commissioner Bruce.
so I think we've kind of boxed ourselves into a little bit of
Yeah, absolutely,
legal
100%.
liability issue here too, because by having an ordinance on the book, we've told the traveling public that we're giving them some sort of assurance on safety and health if they come and stay in one of these VRBOs. And so we do have that side of it also. So I think you either, as Commissioner Durr said, you either move forward and you enforce what you have, or you get rid of it.
Mr. Chair.
Commissioner Roskinek,
Well, I
sir.
appreciate the dialogue today, and I'm pretty open-minded. And obviously, what I don't understand is this program that you're talking about. I mean, that's a whole
Okay.
nother issue. And if this program will do everything that you're saying, and in my head, you have to have a physical person there to do this. But if you got a program for $13,000 that can do all this with minimal impact on your workforce in planning and zoning, and there again, we're talking about safety, and it's always been about safety to me. Safety is always paramount, and forget the dollars. So,
It won't get them all, I'll tell
I'm
you
willing
what.
to make the motion, if that's the motion you're looking for, to buy the $13,000 software and move on.
I'm
So if I may, I know the city of Lead has used this software. They have a very small planning department. I think they have one person. So we can circle back with her to see what her experience was and how much staff time, but she was doing it in Lead, just with her.
And
I
literally,
believe.
if they're paying $100 or whatever, and it covers it, then that's fair. Because they're paying for that service to actually enforce that. But there will be the people that have them, them license plates that go dark when they go through them toll checkpoints. Because those people, there's going to be a lot of people that don't use VRBO or BRB or aren't on that computer system. They're going to screen, but I'm good with it.
I think what's going to happen, we're going to have a fairly large influx in the beginning of this process. But as we go through it in a year or two, I think most of it will be weeded out, and it's just going to be a matter of just minor maintenance and just keeping track. So,
Well, does somebody want to pose a motion?
Looking for a motion?
Yes,
All
to
right, I'm
move
gonna-
forward.
So I'm going to move to direct staff to actively enforce vacation home rental ordinance.
I'll second the
second that.
motion.
We have a motion and a second. Does everybody understand that motion? That's that's intends on you looking at the software, $13,000 bill, and making sure that we are covered by the fees we charge, and if it costs more, then we charge more. That's simple as that.
Well, Chairman, if I may, this kind of goes back to our operating licenses with our septics. Now that we've got them in the system and we have it in a process, staff time, I mean, our office has absorbed it, and it hasn't been, in the beginning, yes, there was an influx, but it's leveled out. and
We
I think
believe you,
this will be
Brittany. We're not
some-
going to give you any more help, though, to do it, so.
I know.
have that.
So all I ask is that you just, on occasion, give us an update how this process is going.
Okay.
Because Ron's going to get the first phone call. Thank you. So the motion on the floor, all in favor say aye.
Aye.
Motion carries. Thank you, Brittany.
And then this is
You have
my-
a Airbnb out there, be prepared. We're coming after you.
So this is our last, I just wanted to give an update on where we are with our Tyler software. So Jason and I are meeting with the Tyler group every Thursday for 2 hours in the morning, working on the build-out for our software program. And we're hoping to have the launch in September, October of 2026. So it'll be functional for the public. So it'll be front-facing, so the public will be able to apply for permits, look up information on their parcels and everything through this software. And then as far as data migration, we did not pay for the data migration for them to do it. In conversations with Box Elder, it was somewhat cumbersome for the cost. So currently, right now, we have staff. We have a part-time staff member that is scanning more information. So we're getting it cataloged to.
You're saying,
eventually-
Brittany, that Box Elder paid them to do it and they didn't think they got their money's worth?
Correct. So that's why we chose not to do it and just kept it in-house.
And so what are you
One-
finding out?
Well, we haven't started uploading it yet, but because we know what our permits are, we know how to catalog them, we know what things they need to go into, what it needs to go under, we felt it was more efficient just for staff to do it because Box Elder paid for it and then they had to go back through and do it again.
Jason is an exempt employee, correct?
Correct, so he
Okay,
can work as
perfect.
much as possible. Yeah,
Perfect.
so-
Thank you for volunteering, Jason.
Hey, good catch.
Yeah. So we're just going to continue to upload. We're going to try to get the first 5 years. I know Rapid City's doing similar. They're going to get the first 5 years, and then we'll just add historical data as we can, so it'll be available to the public as much as possible.
This
So that
this
was just
data
an
all
update.
cloud storage, or is it?
Yes.
So the redundancy's there, so
Yes.
having an AI center in Rapid City would be helpful. Perfect, okay.
So we also have it stored locally. So Mike, we do have it on a drive that's backed up locally, so we have them on PDFs as well. So,
Where do you keep those local drive, in the building?
yes, through the IT department, and then we still have the hard copies, so.
Okay. Perfect, but at some point, can we eliminate the hard copies and get rid of the storage and just call it good?
Well, when the state's attorney tells us we can destroy those,
Well, that
yes,
might
we will.
never happen. Tyler's overwhelmed with stuff to do already, so.
Yeah, because right now they're taking up quite a bit of storage in our
Right, that's my
storage room.
point. It's like, I mean, I don't know that anybody stores that stuff anymore, do they? If you got it on a, if you have it on a cloud somewhere and you have a hard copy in here, I don't,
We're
why does it
hoping
make
that that's
sense?
the case.
Pardon?
That we're hoping that that's the case and we can
Okay.
get rid of it, because it's taking up a lot of our storage.
That's another one on your table there, Tyler. Thank you. Perfect. Does anybody else have any questions on that item?
I'm good.
Okay, good, move on.
Tyler Sobzak, State's Attorney's Office. So we figured we may as well tack on some legislative updates at the very end of this presentation. By way of planning and zoning, there are only a few things and mostly clerical. But the first one I'll bring up is SB 91, which was an act to clarify the procedure for petitioning a Board of County Commissioners for a change to the comp plan or zoning ordinances. And of course, this is in the context of changes initiated by constituents or petitioners per se. It really is more of a clarification bill, but it states that a petition pursuant to 11.228 or 28.1 now must be filed with the Office of the County Auditor, and that auditor shall forward the petition to the commission or a designee, I suppose that'd be Jordan, for consideration at its next regular or special meeting. And within 45 days of that presentation, the commission must hold a public hearing on that petition and make a recommendation. Additionally, there must be a hearing after that recommendation in the timeline set forth by 11.219 and 11.230. So nothing changing really, just making more of that procedure clarified for the public, I suppose. SB 129 updated references in certain statutes to reflect the 2024 building codes rather than the 2021 building codes. That's what Brittany was kind of touching base on earlier. This was one I'd been tracking, SB 3.
Going back to that state
Yeah.
building code thing,
Uh-huh.
is the state requires the counties to adhere to that building code,
Yes.
the 2024, we don't have any, we can't change any of that? It
No,
just-
it's a weird situation, but yeah, they dictate essentially the building codes that municipalities and counties have to abide by. So it looks like they were a couple years late on it, but they went from 2021 to 2024 in the year 2026.
I'd rather have them late than early because some of that stuff is ridiculous,
Yeah.
but go ahead.
Yeah, SB 3, this was interesting one, and it really developed over time, but it was an act to limit the type of residential improvements for which counties, municipalities, and townships may require a building permit. And it now states that a county, municipality, or township may not require building permits for the repair or substantially similar replacement for doors, downspouts, fascia, fencing, gutters, siding if non-structural, soffit, and windows if the dimensions remain the same. So something that's just going to tailor back our ability to have building permits for. But it started really, really broad. It went as far as really anything structural, and it narrowed itself down to, let's call it, appurtenances of a building, I guess. So I think they landed in a good spot, but ultimately the
I
idea
don't think
was,
they required that before anyway, did they?
I don't think we did, but
I don't think the city did either, so.
Yeah, I'd have to look at that, but I don't remember us requiring building permits for the majority of that stuff. Fencing probably, but
Fencing, but that's replacing the fence.
yeah. So this
Putting
is
up a new fence, that's a whole
yeah,
different
you'll still
ballgame.
need, but maintenance of already constructed.
Commissioner Durr.
Yeah, getting back to fencing, I mean, I just checked with the city a few months ago if I had to get a building permit with the property we have in Rapid to put up a fence, and as long as it's not over 6 feet, I didn't need a building permit.
Oh, really? Not as long as it's not over
I
6
think
feet.
ours is the same.
Do we allow us,
Oh, 8. Okay.
ours are 8, I was gonna say, because we allow 6-foot fences, I see them going up.
So, Mr. Chair,
Commissioner Ross, next
so
up,
Jerry, if it was 6 foot 1 inch, would you have to get a building permit?
Yes.
Yep.
Okay.
especially for Jerry.
Good information to know.
So we're gonna go over there and measure Jerry's fence, right?
Yeah.
Tyler? You-
We'll go measure
I'm
that
sorry.
after this.
You have the floor. You're too
no-
serious all the time for me,
Yeah, I
brother.
know. I hear that all the time.
Must be that
Another
law
weird
degree
one.
or something.
SB 237, this is definitely a deviation, and it's another bill that was narrowed down over time, but it's an act that requires counties to provide notice to townships for conditional use applications and appeals. This bill started off, I think it was 75 or 90 days advance notice to the township whenever there was a conditional use permit or so. I know you probably don't like that. But it narrowed down to 10, and I think that's a nice happy medium between giving notice to the townships versus the 75-day, because I think that was a whole process to extend the referendum.
I missed some. Oh, so they're gonna, so on a conditional use permit?
Yep, so the county now must give notice to the township or their supervisor whenever there's conditional use in their limits, and that went over time from about 75 or 90 days to about 10 days notice now. So a lot easier for Brittany and her staff to comply with.
Or 10 days for a conditional use permit?
Yep.
Yeah. No, 75 or 90 days, that just pushes off the timeline on the project.
Yeah, absolutely. I know that there's a lot of lobbyists working to get that narrowed down. But yeah, by way of planning and zoning, those are the major developments. There's a TIF bill that I'm still wrapping my head around that is pretty comprehensive, so I'm sure we'll update you on that when I can wrap my arms around it a
That
little
they
bit more.
passed?
Yeah, it was enrolled. Yep. And there's a couple other open meetings things, but we'll plan on touching base on that this summer at the other, when everything else is enrolled. Won't be in place until July 1st anyways, but mostly clerical. But any questions on anything I discussed so far?
Mr. Chair,
Commissioner Ross,
nothing that we've discussed so far, but is 2 o'clock tomorrow a good time for you guys?
Not for me. I've got to be with Joe up at Box Elders, so I emailed back, and we can talk about it offline.
Sure, okay.
Yeah.
So, Mr. Chair,
Commissioner Drews?
on the TIF bill that Tyler mentioned, I think the main point for us is that one of the things that it requires is that if there's going to be a proposed overlay of one TIF over another, that now has to be in order to agree to that, the entities that would be involved would have to do a resolution to be in agreement with allowing that to happen.
I think that's fair, don't you?
I do too.
Because then that way people can plan about what they're doing. I mean, it's almost impossible to build something in this community anymore of any value that, I mean, for what it costs is insane. I mean, you just look at roads and things. I just was hoping they weren't gonna take the whole tool away from us, so, but I appreciate that. I mean, you think they could figure out how to do some property tax relief. We got a little bit with the, you know, 0.5 taxes to county, but, and that'll come back to owner occupied properties. People don't understand it, unfortunately, but it puts a little bit of the burden on tourism. You know, we are a tourism community, going back to the whole VRBO thing that blows my mind, that we're trying to stymie any of the stuff that we are, agriculture and tourism. That's our comprehensive plan, that's what we stand for. So, you know, make the rules with that in mind, and that helps us out. So I appreciate the professional stellar class operation you guys put on today for us, and
Good stuff.
hopefully we got some resolution for the planning commission moving forward, so. Does any commissioner want to say anything?
Yeah, Mr. Chair. I do have maybe 5 or 10 minutes of personnel matter I would like to cover in executive under personnel.
Sure.
I'm going to make a motion to go into executive for personnel under 125-2.
Under personnel. All in
Second.
favor, say aye.
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 Opposed, same sign. So it really doesn't affect anybody out here, I don't think? Have executive session.
So move.
Have a motion, all in favor, say aye.
Aye.
Opposed, no, motion carries. Motion to adjourn.
So move.
Second.
We are adjourned. Thank you, gentlemen. Great meeting. Do we always need a motion to adjourn, Tyler?